Thank you very much, Mr. President. Mr. President, I beg to move that a bill entitled An Act to Amend the Registrar General's Act, Chapter 1903, the Companies Act, Chapter 8101, the Registration of Business Names Act, Chapter 82, Number 85, and the Non-Profit Organizations Act, Number 7 of 2019, be now read a second time. Mr. President, the bill before us today is comprised of 6 clauses. It is entitled the Miscellaneous Provisions Registrar General, Companies, Registration of Business Names and Non-Profit Organizations Bill 2023, and it seeks to make propitious and significant amendments to several key pieces of legislation under which the Companies Registry operates, in order to facilitate the full legal operationality of the Companies Registry online system, CROS, hence the acronym, the CROSS Bill, which, Mr. President, I shall use hereafter. The laws which we seek to amend today, Mr. President, include those mentioned in the very title to the bill, the Registrar General Act, the Registration of Business Names Act, the Companies Act, and the Non-Profit Organizations Act. And may I say from the outset, Mr. President, that the intention of the amendments proposed by this bill to this suite of legislation under consideration has as its main object improving a number of facets of the ease of doing business and accountability and transparency. So it provides for a system of electronic access, which will enable greater ease of access. It provides for an enhanced and clearly defined concept of beneficial ownership and direct ownership and legal control in relation to legal entities, whether they be companies, businesses, non-profit organizations. Mr. President, the Registrar General's Department, the RGD, falls under the combined leadership remit of the Office of the Attorney General and Ministry of Legal Affairs to ensure that there is a cohesive, enabling approach in the operation of that department. Digitization is a high priority of this government, and I am privileged to lead a ministry well on its way to fulfilling the government's mandate in that regard. I say at the forefront, and I pay tribute to the astute and visionary leadership of the Honourable Prime Minister, Dr. Rowley. A very significant part of the main thrust of this government's digital transformation through the Ministry of Digital Transformation involves working with and deploying the competencies of the RGD. The Companies Registry is responsible for the incorporation of companies under the Companies Act, the registration of business names under the Registration of Business Names Act, the registration of non-profit organizations under the Non-Profit Organizations Act, and the registration of newspapers, indeed, under the Newspapers Act. The government continues to demonstrate a willingness and a commitment to ensure Trinidad and Tobago's international compliance with its international anti-money laundering, counter-finance terrorism, and proliferation obligations, in particular to have available for scrutiny up-to-date and accurate beneficial information, ownership information, with respect to all entities, including companies and businesses. In balancing the ease of doing business, this government has regard to our international financial obligations. As we in this Honourable House are all too aware, the failure of countries such as ours to meet our obligations in this regard is invariably punishable by various forms of naming and shaming or ostracism from the international financial system. And I am happy to say that this country is well on its way to embracing accountability and transparency through CROSS, which is intended to aid our country in meeting our obligations with increased efficiency. Our approach not only enhances the country's standing in the international arena, but also reinforces this government's role as a responsible and accountable global actor. This commitment is evident in the very reason that we are assembled today in this august chamber. The company's registry launched CROSS on the 1st of February 2023, Mr. President. It is a single, fully integrated system designed to accommodate remote, instantaneous, transparent, and secure electronic interaction between the company's registry and its clients in a paperless environment on a 24/7 basis. Permit me some background, Mr. President. The Office of the Attorney General and Ministry of Legal Affairs, the Registrar General's Department, had entered into a contract back in 2019 with a well-recognized and very reputable international supplier of the necessary software for the development, configuration, and installation of this new system, CROSS. The Registrar General made presentations of this new system to critical stakeholders over a 3-month period, June to September 2021. Stakeholders including the Law Association, Ministries of Finance, Trade and Industry, National Security, Public Administration, and Digital Transformation, Chambers of Commerce, business owners, company officials, and the general public. In 2022, critical information was also disseminated by the Registrar General's Department with respect to guidance on how to apply for name reservations, how to register a business name, how to incorporate a company, comparison of business names and companies, change in business names into a company, overview of business names, and overview of for-profit companies, incorporation, fundamental changes, and post-corporation filings. Mr. President, the intended careful integration of the predecessor company registry, that registry system with a new system, met with some challenges which our citizenry will recall. The predecessor company's registry system in December 22 failed, and that left clients of the registry unable to access a number of critical services for just under 2 months until the 1st of February 2023. It was fortuitous that we had already engaged, we, that is to say, the Office of the Attorney General, Ministry of Legal Affairs, through the Registrar General's Department. It was fortuitous with that failure of system that we had already engaged the new CROSS supplier to commence the new system's installation. And that failure left us with no other option but to request the relatively newly engaged CROSS supplier to urgently configure the recently and newly engaged CROSS to provide and to conform to legislation as currently existed then. There was no other system available. The forced premature introduction of CROSS meant it was essentially hobbled in its startup operations as it was not functioning in the manner intended by the Registrar General's Department. Mr. President, this is an appropriate juncture at which I wish to go on record to pay tribute to the resourcefulness and very hard work of Registrar General Karen Bridgewater and her team, and Mrs. Ida Eversley, Senior Counsel, Deputy Chief Parliamentary Counsel, and her team for their relentless commitment to national service, which enabled the hobbled CROSS system back in late 2022 to be introduced partially, and that more effectively even before the stage we've now arrived at to seek the final passage of the necessary legislative amendments to the bill. That hard work enabled us in the interim, Mr. President, from then to now, to bring into effect A, the company's electronic filing regulations 2023 to allow and empower the registrar to collect certain information for the purposes of allowing persons to access the CROSS system. B, the non-profit organization's electronic filing regulations, similarly to empower the registrar to collect certain information for purposes of allowing persons to access CROSS in respect of non-profit organizations. And lastly, the registration of business names electronic filing rules 2023 to empower the registrar to collect certain information for purposes of allowing persons to access CROSS. Mr. President, I am confident that with the passage of the amendments being moved by this bill, CROSS shall be enabled from henceforth to function as it was always envisaged and shall promote positive economic development within our country. The system is intended, among other things, to certify compliance with registration and incorporation requirements, to maintain files and registers, to make documents on file available for examination, to furnish copies of documents, to collect fees and penalties, to institute proceedings in instances of non-compliance with applicable laws, striking off of companies from the register in the case of non-compliance, and to reduce timeframes for registration and the incorporation of business names and companies. CROSS requires users, Mr. President, to register to do so. After that, users may transact business from their homes or their offices, transmitting their documents electronically. Documents can be submitted with electronic signatures affixed. All transactions are securely recorded. All persons on record in business names, registrations, and company incorporations are electronically alerted as to any change in their status. CROSS is intended to both contribute to the improvement and enhancement of the ease of doing business credentials of the country, as well as supporting law enforcement authorities and other relevant entities in the course of their investigations being carried out as they execute their respective mandates. Moreover, the system is versatile and is capable, for instance, of generating the bespoke information often solicited by university students and other specialist clients. Mr. President, on an ongoing incremental basis, the system is intended to reduce the need for clients to visit the physical offices of the Registrar General's department, except in the rarest and most exceptional of circumstances. One shall generally be able to transact most business with the company's registry from the comfort of one's home, as well as allowing registrars and registrants to comply with the document filing deadlines, removing the requirement to go into the registry physically. The government is fully aware of the way the impact of the COVID pandemic has forced persons to work remotely from home and to ensure continuity of business operations, particularly for small and medium-sized businesses. And Mr. President, to date, many registrants are utilizing the online system to transact business electronically. There are other fundamental benefits which shall be obtained from CROSS, some of which are fraud prevention and mitigation. CROSS accounts are password protected. All authorized officers connected with a company are immediately notified of transactions. This will mean, for instance, that the instances of persons being either removed or appointed as directors of companies without their knowledge should become virtually non-existent. To be clear, one must first be associated with CROSS, give the necessary consents to being appointed as director of a particular company. CROSS matches data from the civil and companies registries, which enables the detection of fraudulent cross-account registrations. It will provide for enhanced ICT support. The Registrar General's Office remains committed to its proactive approach in delivering excellent ICT support for the CROSS systems and services. Strengthening this support, particularly in cybersecurity matters, is crucial for bolstering the digital infrastructure across government bodies. To achieve this, the Registrar General's Office will emphasize a comprehensive implementation of multi-layered cybersecurity measures. These measures encompass network security, endpoint protection, data security, identity management, incident response, and ongoing training. It is important to note, Mr. President, that these measures are not limited to the ICT department alone. All units within the Registrar General's Office will actively participate. This collaborative effort forms a robust defense against the ever-evolving cyber threats. Secure designs of systems and services. The CROSS systems and services were constructed with security as a top priority. This involves incorporating security measures at every stage of system development and ensuring that security is seamlessly integrated into the system's architecture. Data encryption and secure data handling. To provide an extra layer of protection, robust encryption measures are implemented for sensitive data at rest and in transit. By adhering to secure data handling practices, the integrity and confidentiality of the data is safeguarded. A secure network infrastructure. By employing secure network design principles, such as segmenting and isolating critical assets. The infrastructure is fortified against potential breaches. This approach also restricts unauthorized lateral movement within the network, enhancing overall security. And there is as well, Mr. President, backup and disaster recovery systems. To ensure business continuity, a robust backup strategy and comprehensive disaster recovery plans were meticulously developed, and these measures guarantee the availability and integrity of critical data in the event of any cyber incidents. Migration of the company's registry to a fully digital space, enabling all clients all around the world to register businesses, incorporate companies, and to conduct corporate searches on a round-the-clock basis. The intake of paper into the registry, Mr. President, shall be greatly reduced. CROSS shall obviate, or at least reduce substantially, the need for us to build or otherwise source additional and expensive storage space insofar as the company's registry is concerned. Mr. President, we've also taken the opportunity to clean up lacuna in and modernize the subject legislation so that, for instance, just as an example, archaic references to Commonwealth in the registration of business names are targeted for removal. In addition, the stipulation of Section 41 of the Companies Act to make provision for articles of incorporation to be filed in paper form, in duplicate, which is incongruous in an electronic and paperless environment, will be addressed. My contribution today, Mr. President, will just look at the clauses in some small detail of the bill which is before us. There is, of course, Clause 1, the commencement section. Clause 2, rather, the commencement section. Clause 3 of the bill amends the Registrar General's Act, and it is interesting to look at some of the new definitions which are provided for in Section 1. A new Section 1A of the Registrar General's Act will introduce definitions for administrative documents, data message, document, electronic system, information system, public record user, and very importantly, user account unique identifier. Section 2 will add the post of Senior Assistant Registrar General and a new subsection 2.4 which authorizes the use of an official electronic seal by the registrar. Mr. President, there are a number of other significant changes that have been introduced, all geared towards developing an inclusive electronic system. When we look at the new Section 5A to L, we see that those new sections will provide for the use of an electronic system to carry out the functions identified under Section 53 of the Electronic Transactions Act, which allows all government offices, public bodies to conduct their affairs electronically for some time now. And I have already emphasized the intended use of the user account, unique user account feature that is provided in the amendments proposed to the Registrar General's Act. Section 6 will introduce, again, new sections to provide for the issuance of certified copies in any form, inclusive of electronic form, and a number of other amendments which provide for a measure of immunity to Registrar General staff who function in good faith and in the discharge of their due performance of their other functions. All designed, Mr. President, to provide, as I've said, for ease of doing business in the Registrar General's Department. The Companies Act, Mr. President, is also to be amended by the amendments which this bill brings to this House. And we see in the interpretation, Clause 4, that there is a new definition of authorized corporate service provider, which will now read, authorized corporate service provider means an attorney at law or accountant who is registered with the Registrar General to perform functions pursuant to the company's electronic filings regulation 2023 and with the authority to act on behalf of and to bind an incorporator, director, or secretary of the company. And we will see throughout all of the legislation that is being proposed to be amended today, the 4 pieces of legislation, we will see the use of that term, authorized corporate service provider, which will enable qualified persons, attorneys at law, or accountants to assist members of the lay public in accomplishing the desired objectives under the new legislative suite that has been introduced. We see as well, Mr. President, the introduction of the definition of beneficial interests, which means an interest arising out of the beneficial ownership of shares, debentures, or memberships. And again, we go to, if we were to go to immediately section, and this is one of the more important parts of the amendments being introduced by the Companies Act, section 337 2C, to amend the interpretation of certain words. The definition of beneficial owner will now apply to both companies registered under the Companies Act as well as to external companies. The definition of beneficial owner will include the natural person who ultimately owns or controls 10% or more. And this is one of the developments that this amendment has taken us from 2019 up to 2023. The person, the natural person, who ultimately owns or controls 10% or more of the shares or membership interests of the company through direct ownership, indirect ownership, or control through other means other than in the case of a company listed on a regulated market. That is subject to disclosure requirements which ensure adequate transparency of ownership information. That concept of beneficial ownership, Mr. President, is central to the embrace of this country of its obligations in relation to anti-money laundering, to countering terrorist financing, and basically making the ownership of companies transparent so that persons who seek to invest in companies for the purposes of doing legitimate business are available to be interrogated, to be inspected by the relevant agencies on an inquiry through the registry or other facilitative endeavors. And no longer will we have the situation which has existed for far too long of ownership of companies by names in the top drawer of someone's office, which is never registered and never therefore available for transparent inspection. Section 337 is to be repealed and replaced with the new sections which will provide, this is section 337 of the Companies Act, Mr. President, which will provide for a statement in respect of beneficial interests, issuance of a notice to submit a statement where the name of the person is entered in the register as the holder of 10% or more of the shares. Where no notice is received, a statement is to be submitted in the prescribed form to that effect. Requirement for persons holding more than 10% beneficial owner and does not have his name registered in providing for submission in the statement, and requirement for where there are changes to the beneficial ownership of the shares or membership to submit a statement within 14 days in the prescribed form, with penalties being applicable for failure to comply with the requirements to file the requisite forms and returns. Section 337D is to be repealed and replaced with 2 new sections, again providing for a requirement of the Registrar General to keep a register of beneficial owners, and upon receipt of a return to update the register. And Section 337DA empowers the Registrar to monitor the beneficial ownership information that is provided in that register. Mr. President, there are any number of other significant amendments, but they all go to the concept, as I said at the outset, of transparency, accountability, and enabling the Registrar General to be able to ascertain accurately the beneficial ownership of any company over and above 10% in any internal domestic company or external company. It doesn't apply to those on the share exchanges, on the share markets, because of course they are regulated. Then we have the Registration of Business Names Act, Mr. President. Again, we see Clause 5 provides for the authorized corporate service provider, which I had spoken about earlier, and we have that very comprehensive electronic system which is going to enable persons who are registering businesses under this new legislative suite of improvements to be able to gain access to the relatively important transactions that are being conducted through electronic means. And again, we have the authorized service provider, that is to say, either the attorney at law or the accountant who is enabled to assist persons in maintaining their profiles and their business under this particular piece of legislation. And then we look at the Non-Profit Organizations Act, Mr. President. Clause 6 of the bill amends the Non-Profit Organizations Act and provides again new definitions in Section 3, authorized corporate service provider, which will allow for an attorney at law or accountant registered with the Registrar General to perform functions pursuant to the Non-Profit Organizations Electronic Filings Regulations 2023, and who has been authorized to act on behalf of and to bind a controller. A constituent document defined under the Non-Profit Organizations Act includes any statute, letters patent, memorandum of association, articles of association, articles of incorporation, articles of amendment, certificates of incorporation, certificates of continuance, amendment, bylaws, regulations, evidencing any membership or affiliation to which a non-profit organization has subscribed, or any other instrument that governs or regulates the affairs of a non-profit organization. Mr. President, again committed to the concept of ultimate transparency in the regulation of the affairs of artificial entities carrying on the business in this company. As I come to a close, Mr. President, I emphasize Trinidad and Tobago continues to make progress on its digital transformation journey, including building good foundations on its digital infrastructure, government policy and leadership, enabling regulation and improving the uptake of digital products and services across businesses and wider society. The cross-system captures all AML CFT requirements in the package of laws passed by the government in the last few years, including most recently the bill that came in the Global Forum bill before this Senate not too long ago in the last couple of weeks, what the company's ordinance amendment of beneficial. Yes.
Thank you. Just through you, Mr. President. I've seen a number of clauses which focused intently on codifying criminal offenses for tampering in electronic measures. What one would normally find in a cybercrime bill, is that included here in the absence of that? And what happens if cybercrime law comes to the Parliament and is passed in those instances for those clauses?
I'm not sure if I follow the question. May I ask you to repeat,
yes,
Senator?
Sorry, there are several clauses which focused on criminalizing tampering with data and material inside of this legislation.
Yes.
Which one would normally find in a cybercrime law, if I'm not mistaken. Is it that the intention is for this to work in harmony if cybercrime law is passed eventually, or it will be replaced?
Well, this suite of amendments, as I said at the beginning, is intended to stand on its own in respect of the different pieces of legislation that we are looking at today. And for violation of any of the obligations, there will be their own discrete penalties and or other offenses that can be created. But yes, to answer your question, in addition to the standalone capacity in this suite of legislation that we are asking the Senate to pass today, it will also be read in tandem with the cybercrime legislation, which the Law Revision Commission is working on at the moment, and which we will be bringing to Parliament shortly. Yes, thank you. So if I may continue, Mr. President, I was in the process of saying that the cross system captures all of our anti-money laundering and counter-financing terrorism requirements, and again, addressing the question that Senator Richards just asked in a different context, the concept of beneficial ownership, which is enhanced in the definition found in the proposed amendments in the Companies Act, will also apply across to the Global Forum package, which we passed in the Senate not too long ago, within the last 4 weeks, so that across the board, both in respect of Global Forum and Financial Action Task Force measures to control the law enforcement in the country and to bring it into compliance with international standards, these measures can only see positive results as they make Trinidad and Tobago more compliant in the eyes of various international monitoring bodies, consequently encouraging greater foreign direct investment. Mr. President, this government continues to work closely to ensure that Trinidad and Tobago becomes fully compliant with its international obligations under the Global Forum and the Financial Action Task Force family of legislation and measures. And as the world becomes increasingly digitized and cross-border activities become more and more the norm, we recognize that administrations need to work together to ensure that there is improvement and investment in key digital economy foundations in order to deliver reliable, high-quality connectivity and accessibility, improving the digital literacy of business owners, which will all contain and provide for essential elements in this continued progress. We have to work steadfastly and with great speed towards passing this legislation, and I implore this august chamber to accede to the request of this government to pass this legislation. With respect, Mr. President, I beg to move.